basically,
Five and six.
He's basically saying keep the language as is, except for 5 and 6.
The
Right.
components that,
What's wrong, how about seven?
But did you want to also condense?
I want to know why we're saying leave 5
Okay,
and 6
Stan.
out first. We didn't discuss that.
On the automatic refill,
Yeah.
there's, I'm just going to share a long-term care perspective. And it's a double-edged sword. I'm not talking about people who are 60 or 70 years old, but probably more to the 80 or 85. A lot of confusion in getting their medication, a lot of order changes. And typically what is seen in long-term care when these people finally get to some type of assisted living facility, they come in with 15 and 20 drugs, and they pare them down to 8 or 10. And there's a whole list of medications that are not supposed to be prescribed to geriatrics. So where I'm headed is, one side is that, and I'm just going to pick an age, that 85-year-old individual truly needs an automatic refill because they're not going to remember this. And the other side is there's multiple medications that that patient may be having that's doing them more harm than good. If there is a chance that an age consideration and an evaluation of that patient, and I'm thinking of like a little MTM on that patient, you may be doing an extremely good service to the elderly people, and as we all know, the baby boomers are here right now, and it may not put an enormous amount of extra burden on that pharmacy. In the long-term care environment, they compare orders that are automatically sent to the physician orders on a routine basis. That doesn't happen in the retail arena. Just another challenge for you to possibly think about. Thank you.
Thank you, Stan. I think we've got another public comment, and then we can do you, Steve.
Steve Gray from Kaiser Permanente. I would just also suggest, just so that it'll be smooth going forward, because I think there are multiple sides to this. We've heard a lot of that. But I've also heard out there that they're wondering if staff has done an analysis on whether this is going to take legislation versus regulation, or whether the board has the authority to put restrictions on these auto refills under the current statutes. I think that staff needs to be asked to do that analysis so that we don't get partway down this and then we have to start all over.
That's a good point. And Laura, maybe you can advise us on that.
This is something that happened to me over at the House Ear Institute. It might be of help.
Does this pertain to the automatic refill?
Well, yeah, no, I'm talking about the returning of drugs that I heard you guys talking about. It'll just take me a second.
Okay.
Anyway, they had this lipoflavonoid derivative for tinnitus, the ringing in the ear. And this gentleman came in, he bought it, he went home, took one, he said, I had the most violent reaction I've ever had. You know, anything can happen. He says, I want my money back. And I said, you know, once that drug leaves the pharmacy, you bought it. I mean, that's it. Look at my point. You're taking it, giving it back to me. Would you like it to give it to somebody else? I can't give drugs that you're taking back. Anyway, this guy was a real, I don't know if he's a lawyer or what, but all of a sudden I get a call from Visa, and they say this gentleman wants his money back and you won't give it back. And I said, well, this is the rules that I know by. And she said, do you have a sign posted up on your thing that's large enough that says medications cannot be taken back? I said, no, I don't, but it's kind of an thing that if medicine goes out of that pharmacy, you're not going to take it back because what are you going to do with it? You can't give it to anybody else. Said you didn't have a sign up there, you're giving the money back. And I said, you're kidding me. I said, she said, that is our law. So if you, my point is, maybe you better put up a sign if you're going to take back medicine or something. because if Visa, American Express, MasterCard gets a hold of it, you have nothing to stand on. And he did get his, I appealed it, we went through 3 appeals, and he finally won.
Thanks, Steve. All right, we have a motion and we have a second.
Yeah. And
To move forward.
let me explain that.
Okay.
If Cheryl had asked, why not leave in number 5? And I said, well, basically, if you have 7, you don't need 5. So I think we would all agree to that.
That's true.
So that's why I wanted to condense it by taking out 5 and 6.
And your motion is to, besides removing 5 and 6, having the staff work on this and bring it back to the next board committee.
Yeah,
Right.
that's what I'm saying. Why can't we let the committee look it over and then come back with it? I mean, right now, we didn't even look at closely on every one of this. So we're not agree on any of those.
Okay, and Debbie, you're okay with that second of Greg's motion? Okay, all in favor?
I guess we're not going to get it.
That's 4. So we've got Victor,
I should just bring
Amy, Debbie, and Greg.
Ricardo, did you vote?
I wasn't part of the discussion you guys had earlier, so
Alan left.
What are we doing now?
We're voting.
We're voting on Greg's
On my
motion.
motion.
So this is
In favor. Okay, opposed?
1, 2, 3.
Okay.
Carries.
So is there a subsequent motion that someone would like to make?
No, that's
Well-
okay, it passed.
It
Oh, it
carries.
passed? Oh, it
Where's
passed.
Excuse me,
Alan?
there was, you abstained?
4 to 3, it passed.
Okay.
Where's Alan?
Can I also ask
Can we wait
Laura,
for Alan?
if you could review the comment that Steve Gray made, does this require legislation?
We don't, Desiree and I just spoke about it, and neither one of us believe that it will. I mean, there's a possibility that we could run into something later that might change our mind, but based on the broad authority that the board has under 4005 of the BMP code, we think that a regulation would be the appropriate vehicle at this point.
So it carries.
Okay.
All right.
And we're bringing it
Alan,
to, and we're bringing it to the
94.
board meeting, is that correct?
Yes.
Alan wasn't part of it.
He was part of the discussion.
but he's
All right, moving on. Yeah, let's take a 10-minute break. We're going to meet back here about 3:20.
Okay. I just say let the committee take the
Okay, we'll start up. Oh, ready, Cesar? Okay. Ready to go? Laura, did you have an announcement before we get started?
Yeah, I just want to make a quick announcement. Earlier, there was a comment that was made, and it was a joke, and I understand it wasn't with any bad intention. But this is a state building, and it's a state meeting, and this body has an obligation to be professional in its demeanor and not have comments made that have sexual overtones. And so I just want to keep that in mind as we move forward so that we don't have a repeat of that.
Thank you, Laura. Moving on to item F, discussion and consideration of the National Council of State Board of Nursing Nurses e-Notify system. So the Enforcement and Compounding Committee expressed interest in learning about the system. And what it is, the National Council of State Board of Nursing, it's a nurse licensure notification system that employers use. And it lets them know whether a registered nurse or an LPN, LVN, and it gives them real-time email notifications about nurses they employ. So it alerts subscribers when changes are made to a nurse's record, such as their license status, their expiration, pending license renewal, any public disciplinary action, resolution, and alerts. The committee discussed this system for use for pharmacists. Ms. Harold commented the board tries to obtain the National Healthcare Integrity and Protection Data Bank reports on all licensees. And that gives you similar information, Jenny? The National
Yes.
Healthcare Integrity and
believe it's-
Protection?
Yes, we believe it's.
And
similar.
it's a cost of $2 per licensee?
If we were to request a report on you, it would cost us $2 to get your report.
Okay. And what value would that add to us?
We could find that you had been convicted in Texas, revoked in North Carolina, and lost privileges in Michigan.
Oh, that's actually a pretty good system. And right now, we have to wait for those systems for them to notify us or for the licensee to notify us.
We get them,
A little bit more on that. I want to interject here because as I was reading this, I was thinking that we get it from the arrest records. I mean, there's thousands of arrest records, daily in California. How does that filter down to us?
when you're arrested, you're
Notice she said when, not if.
Perhaps that was an unfortunate choice of words, and let me start that over
She
again.
already had me doing all these things in other states, okay?
I was running out of states too, actually. When your fingerprints are on file, so when you're arrested or convicted, we are notified. So if it occurs in California, if the secret, I don't think that this is too big a secret, but I'm going to let it out anyway. At the time you apply for a license, we do a federal check, but the federal check is a one-time snapshot in time. So on December 22nd, you were clear, you get arrested on the 23rd, we're not going to get it. But if provided we do the check on the 22nd. But what you are required to do now at time of renewal is you certify under penalty of perjury that you've had no convictions or arrests since the last renewal. So if you misrepresent that and we later find out that you were dishonest, we take action not only for the action that you were arrested for, but also for your dishonesty at the time of renewal.
Okay, and so, but when you find out that I'm arrested, you found out because of a check on my fingerprints?
Because the Department of Justice matched your fingerprints at the time you were arrested or arraigned or whatever they do to you. And then we get a notification that Alan Shadd had been arrested on December 22nd.
Yeah, you can't hide this anymore, Alan.
Technology.
And we use non-pharmacists to investigate these, but we have a unit that's set up. The Board of Registered Nursing kind of got us this model, if I remember correctly, where they were not doing anything. We tried to absorb the workload, and when they had a problem, we were able to justify the need for additional staff. But we don't need pharmacists to look at these things. These are non-pharmacist duties, and so they write up a report.
So what is this particular,
What's the difference?
what does the data bank report give you that you don't get from the?
Well, that's for nurses, and the board just wanted more information about it, which is why we provided to you.
So is this available only for nurses, or is this
That
also
particular
pharmacists?
system is only for nurses. The HIP data bank is for all healthcare professionals. We're all required to report to it. The problem is that if every year we run a HIP report through them, we're going to have to pay $2 per individual licensee, and we don't know that you were arrested but not Debbie, or the other way around. So we would have to do everybody, and we requested a budget change proposal one year to do that, and we were denied, and they said, no, find another way, which
Can
is
we
why
pass
we
it
require.
through?
Pardon me?
Can we pass it through?
Well, we could, but the alternative is we have you certifying under penalty of perjury on your renewal that you haven't been arrested or convicted of anything.
But if they're going to
And
lie, they're going to...
ultimately, it gets back to us. Somehow or another, it gets back to us.
So
We may
what
not
if-
get everybody,
What if
but
we did it at license renewal, which is every 2 years? That means you'd only run them every 2 years.
we could add that if you want to do that. That would probably be a regulation at the very least, if not statutory
If
modification.
we added $2 to their,
The
Right.
fee alone would be a statutory, probably.
The fee would be, for sure. If it's something that the board could do on its own,
You want
then
to
I don't
explore
think it
this?
would be. If it's the national organization that would have that data, is that correct?
It's a federal agency that manages it, but all regulators, employers are required to report into it.
Okay.
So we require it under certain circumstances. Right now, it's a condition of application. So they have a function where you can do continuous query, where you enroll, you say, these are the people that I want you to notify me on, because it's public information. Employers can also enroll people. So if you wanted to check on your 5 employees, you could enroll in this continuous query option, and then if there was something that happened, you would be notified of it. And I think you have to enroll on an annual basis.
So this
it's
is
not
the
a-
HIP program, not the nurse ESIS.
No, I'm talking about the HIP program. The nurse one, I think, has like employer features and things like that that are not present in the NPDP. The NPDP is really discipline as well as practice restrictions and those kinds of things.
So it's not a one-time enrollment that you just say, I want to check right now, real time to scan. This is an enrollment where you enroll a group of people and they just notify you when things come up.
There's two options. You can do the one-time search or you can do the continuous query.
And what does the one-time search cost?
I'm thinking, so I'm going to guess, I think when the applicant does it, I think it might be $4 or $5. I don't remember, I apologize.
Okay.
Oh, so so there's a way did you say that the applicant does it?
At the time of applying for a license.
So the applicant could give you a copy of that along with the license?
They do a self-query. So they request the self-query, but then it comes to us in a closed fashion, so we know that they haven't had an
And
opportunity
that was like
to
the
change it.
technicians or whatever,
Yep.
right?
Yep.
So all the applicants are doing that right now?
The technicians, not the pharmacists.
Why do we just do tests?
I think that we have regulations in various stages. I don't remember if pharmacists are already done or if that's coming.
So from the technicians, have we gained any information that we didn't have before from our experience with that?
We have had a couple that have come in saying that, yes, there was action. I do not remember if they had self-disclosed it as well, or if we found the information from the query itself. Do you know what I'm saying?
Yeah, so maybe it might be worthwhile just looking and seeing whether there's been any value in the program before doing anything.
Hey, you want to push this off to licensing, since I think it was licensing
Yeah,
that did the.
great idea.
Yeah.
And see whether maybe
Don't
we
look
can
too
look.
excited, Stan.
How long have we been doing the technicians, Ann?
A couple of years, I
was gonna
think.
say,
I'm going to
yeah,
have to
So
check.
go back a couple of years and see what our experience has been and whether it's something that would be beneficial to expand or not.
Okay.
Okay, so we have to make a motion to send it back, to send it to licensing or not?
Do we need a motion for sending it to license?
we
can just
heard
do
what
it.
you did,
Yeah.
just,
Okay,
We'll just add it to the agenda,
okay.
and we can just punt it to licensing from enforcement.
Okay.
Any public comment? Okay, item G, discussion and consideration of possible revision to Title 16, California Code of Regulations, Section 1707 on off-site storage waivers. And this is to address licensees with previous record violations. In recent months, the board has identified that several pharmacies have requested off-site storage waivers, and they were ineligible for waivers because they were cited for not having the waiver in the first place. So their attempt to get the waiver was generated by the citation, and they wanted to become compliant, but the regulations from the board provided no option for the board to grant such a request. So the staff had requested to the enforcement committee to modify 1707, and there's a copy of it in attachment 5, and it basically says it changed into 1707 under A. It said a waiver instead of shall, it says may be granted to any entity licensed by the board for storage of the records outside of the license area of the pharmacy. So we changed it from off-site storage to outside the license area of the pharmacy, because there may be locations where it may be within the building, but it's not in the licensed area of the pharmacy. And then we removed the whole section after Business and Professions Code 4105 that states unless the applicant has within the preceding 5 years failed to produce records pursuant to Section 4081 of the Business and Profession Code or has falsified records covered by Section 4081 of the Business and Profession Code. So we believe the committee is recommending that the board approve the proposed changes to Section 1707 to make it consistent for applicants who have issues like such as this to become into compliance.
Move to approve.
So my only thought is, by moving it to records outside the licensed area of the pharmacy, I recall when I was working in the pharmacy, there's not a lot of room to, store prescriptions. So we would seal them and store them in a remote area of our warehouse. So that would be outside the licensed area, so that means all of our stores would just need to.
It's still off-site storage, because if it's not, you mean the warehouse that's in the building or in
Yeah.
another building?
No, it's in the building.
They have to be protected from access from non-pharmacy employees.
Yeah,
And-
it is.
And so
We
that would
kind of
be a
went through the
violation
whole
if they
step.
didn't.
We kind of went through all the, I remember we went through all the steps in the past, and I don't think my company is unique, but
No.
I think they're like shrink wrapped and then they're put up in the rafters.
Well, we've had a beef with some of the shrink wrap things that we've seen where they're back in a storeroom that service delivery people come in and deliver other products for other portions of the store in. Those we don't think the records are secure enough, even if they're partially shrink wrapped, because we have pictures where the shrink wrap has been shredded and partially exposed.
Okay, I guess
Our reg
I'm-
requires that it's prevented from access from other individuals. It's the same security that the pharmacy has with respect to.
Okay,
But I
I
think
guess,
that
I
the
guess I'm-
focus
that's
study-
really not my focus. My
Okay.
focus is that that is outside the license area of the pharmacy.
Right.
So all of those situations where, and once again, I don't think it's, I described how I recall it happening, but I know that there's, pharmacies that have built cages like in the back of their pharmacies in the warehouse.
They rent
which is still on
storage
the
space.
premises, right.
They rent storage space sometimes too.
So
But
I
I'm
think
saying, but it's in the building.
the whole concern was
So
that
that would-
What's the question?
concern, so wait a minute, you guys, so I don't think you're getting my question. My question is this, that it's still in the building, but it's not part of the license area. So all of those pharmacies would need to.
An off-site storage waiver, yes.
Would have to get one of these
The
waivers.
concern with the committee discussion
And that's
that
fine, I'm fine with it, I just want to make sure that
off-
you know.
Well, I think the concern was that off-site was too vague, what that meant. And there was confusion and there wasn't consistency on how that was being applied. So at least having it say outside the license area of the pharmacy is much more clear than just off-site. I think
Right.
that's where the discussion.
I just, my only point is that, I mean, you're going to get a lot of pharmacy waivers, because most pharmacies don't
Theoretically, they should
put
have been
their-
waiver, they should have gotten one anyway.
No, because this said off-site, so that means off the,
But it depended, I think
But-
the problem
So it
is
was not
that
in the same
it
building.
depended how they interpreted off-site. So if they interpreted off-site, like Ginny said she's already getting them. So if they interpreted off-site as not being within the pharmacy, then they would have applied a waiver. It was just too unclear.
yeah, and I think what happened in my past is we did talk to the board, and within the building was not considered off-site, so we didn't get a waiver. But now I'm only pointing out that you're going to get a lot more waivers.
Okay.
Well, the intent is to help the pharmacies keep their records nearby, but get them out of the valuable pharmacy space if that's what they need. And the way the reg was written, it was so restrictive that the very people that perhaps most needed it were barred from being able to use it.
So we'll have to do some education and subscriber.
All right,
training, all
can
of
we
that.
clarify that? So if the pharmacy, they have too much files, they move it to a room next door to store all the prescription files, which is not accessible to the public, they could have a lock on it, then do you still need an off-site permit?
Yes,
Waiver.
you would need it, because these records have patient, privacy concerns and HIPAA
So
concerns.
So even though if they are not accessible by the public, you only have to lock by the pharmacist
Well, you have to
himself.
make sure that non-pharmacy staff does not have access to it
Right,
as well.
right.
So it would be only pharmacy staff that would have
Only
access.
pharmacy staff have access, then you don't. But if not, then you will have to apply for off-site.
No, because even if the pharmacy staff has access, but it's not in the pharmacy, by this, you would still have to get a waiver.
Yes, you still have to get a
So you would still
waiver.
have to get a waiver.
You still have to get a
You would
waiver.
have to get a waiver.
Yeah, I just want everybody
We
to know
believe
that.
That was the change the board made at the last meeting, but we'll, if there's a change, if you allow us to notice it, if that is going to cause that, we'll bring that information back to the board.
It'll come
So,
back in
I'm
public
sorry, you said the
comment.
board made it the last meeting, it was the committee meeting, right?
Yeah.
Yeah,
Is that on
I'm
the
sorry,
record?
yeah,
Okay.
I'm sorry. the
But
committee.
all this will come out in public comment too. when we
Yes,
release the-
I suspect we may hear, it. If two of you had that comment in here, maybe three of you, we'll hear it from the population at large as well.
Okay.
I have every confidence.
So the committee recommends that the board approve the proposed changes to 1707 and initiate rulemaking.
We have a motion and a second.
Well, the committee made the recommendation, so I don't
Oh,
think
we
we
didn't
need
need
a
the
second.
second, okay.
So we just need to
didn't
get
We
public.
didn't need the motion either then.
Yes, we didn't. We just need public comment.
We may need another break.
Steve Gray from Kaiser Permanente. I almost feel like I should apologize because I think I was the one at the meeting
You
that
were,
raised,
you were, Steve.
that raised the
I
confusion.
didn't want to say that, but yes, you were.
The confusion comes from the statute has different words than the regulation. The statutes refer to premises. They never refer to off-site. So when we adopted the regulation of off-site, then we got mixed advice from inspectors, including supervising inspectors, who said that, oh, as long as it's still on the premises, meaning in the building or meaning on the campus, then it was okay. And so a lot of pharmacies did exactly what Board Member Veal said, that it's still in the building. Now, I think this is okay, except that realize also that how would this apply to the hospitals? Because hospitals have a hospital pharmacy that has a defined space, but they don't store all their drugs in that defined space. They have satellites. So I think that this works well as written if it were non-hospital. You may have to modify it to say, because if you think, space is at a premium, in a hospital it's super at a premium and very expensive. So I'm saying that perhaps you need, going through the regulation process, you need to think that there's kind of one rule, because remember, the hospital is a licensed space. They have PHI secured according to state and federal law all throughout the hospital.
The whole hospital.
Yeah, the whole hospital. And so I would think that, that a hospital pharmacy could store it in the hospital and they wouldn't need an off-site waiver. But, so that's the difference between what's written and so forth. But again, it goes back to the ambiguity in the multiple places in the statutes where the word premises is used with several different meanings depending on the context. Thank you.
Thank you, Steve. All right, we have a committee recommendation. All in favor? Okay. Moving on to item H, discussion and consideration of a possible amendment to a new Business and Professions Code 4316 regarding cease and desist orders. Last year, there was one provision that was contained in the board's sunset bill, SB 1193 Hill, that provided the board with the ability to issue a cease and desist order to an unlicensed entity operating within the board's regulatory jurisdiction without a license where one is required. However, following enactment of this bill, staff identified items in the provision that needed clarification. There is attachment 6 is the proposed language that came from the Enforcement Committee. The committee considered the proposed changes, received input from council, and committee agreed with recommendation that we need to have some regulatory language that describes the proposal to amend 4316. Yeah, the committee recommended to approve the proposed amendments to Business and Professions Code 4316 and to initiate rulemaking.
It's not a rulemaking, it's a statutory modification, so
Okay.
we will give it to an author to pursue the technical corrections that we should have done last.
So can we go on based on the committee's recommendation, or do we need a motion
No,
for
you have a
statutory?
motion there. That's
Okay.
your motion.
All right. All right,
I
any
don't know,
board
does it
member
say this is
comments?
Recommend the board approval of the proposed amendments to BMP code. No, it's a statutory.
Statutory, okay. Any board member comments, public comments? Okay, all in favor?
Thank you.
All right. I, discussion and consideration FDA's article, Drug Supply Chain Security Act implementation, identification of suspect product and notification guidance for industry. In the interest of time, attachment 7 provides a copy of Dr. Ignacio's presentation and the FDA's guidance regarding this issue. I don't know, Jenny, is there anything we need to do? It's basically the board's going to have an article in a future issue of the script and provide a copy to the other healing arts boards.
This is an important guidance in the sense that it starts laying out some of the circumstances upon which supply chain breaches have to be notified both up the supply chain, back up to the manufacturer and to the FDA, and all the way down to a pharmacy where it may appear. And they give a whole series of examples where a compromise may occur, or a suspect product may end up appearing somewhere in the supply chain. And it hones in on the reporting requirement to make sure the supply chain in the U.S. is safe. And it follows up a little bit on what we did when we were doing e-pedigree. Some of the examples were ones that we were aware of were problems. And it's just, and whereas that is not an exhaustive list, it is a list of breaches that occur in the supply chain that the FDA say warrant upward and downward notification.
And the committee did not recommend submission comments to the FDA
No.
as a result of this?
No, other than just to provide, we've been on on point on this one for quite a while, for a number of years, since 2004, 6.
Any board member comments? Public comment? Okay, moving on. Item J, discussion and consideration of beyond use labels in institutional settings. You may recall at the December board meeting, we had a request from Providence Hospital to review a ability to utilize language that says "do not start after" on labels in a hospital to make it clear for nurses so that they understand when they cannot hang an IV bag. Typically, when you do hang an IV bag, the "do not start after" is very important because the expiration may be misleading and confusing to the nurses. So we discussed it at the committee. The committee basically stated that as long as a licensee meets the minimum label requirements, and I don't believe in, Laura, there was no requirement that we have expiration on the label per se.
There is a requirement that the expiration date be on the label, but I think that a language that said something along the lines of "do not start after" would provide that expiration. I mean,
Okay,
the reason for having that "do not start after" or "do not administer after" or whatever
Would
the
be in lieu
language
of the
was,
expiration.
does reflect the expiration of the product in there. Now, if there's some specific, for those licensed members, if there's some specific meaning that expiration is a specific date that you're aware of, then we can revisit that. But I think from my perspective as simply an attorney, I think that the alternate language would satisfy it. The board could still do a regulation to kind of clean it up and make it clear for public, but I feel like that's a reasonable interpretation of that provision. I don't know if you want to add anything, Desiree.
And I think it would be confusing to put expiration and "do not start after" because it may be very confusing to nurses. They wouldn't know which one to use. So I think it's actually safer to do that, the "do not start after" in lieu of that, as long as it does reflect expiration.
Well, presumably that would be the only reason you would put
Yeah.
"do not start after" is because if you started it after that point, by the time that the medicine was administered, it would no longer do what it was supposed to be doing, right? Or it could be unsafe. So
Desiree, did you have?
In that regard, I think the language.
No, I agree with Laura that "do not use" after a certain date provides the expiration date, and that particular situation would satisfy the requirements of the section.
Okay.
So, "do not use after" is an addition to the information that we require on the label.
Right, but it's instead of having to write expiration.
Okay, so that was my question.
So it kind of means expiration, and you can use that in lieu of if you're preparing an IV product for administration, that is actually more suitable than putting expiration.
It was
The drug may expire later, but the "do not use" "do not start after" is actually more critical.
Right, but the expiration could be different than the "do not use" after.
So and the reason I brought that up is because the summary in the packet says that it's additional, and I thought that having it as additional in addition to EXP would lead to confusion. So I wanted to clarify that.
Well, that's what it says, and that would be the logical thought that somebody would have, but it's additional information, not replacement information.
Yeah. And the reason this is important is the Providence system, much like other health systems, they would like to reprogram their EHR to reflect this "do not use" "do not start after," and to do so, that's very costly, and if we're not going to approve this, it would be, or reflect it, or see it as an expiration, it was going to create some programming issues down the road. So the committee recommended that we are fine with that we approve it, and that we include this in a future news article in the script.
So do I remember a discussion some time ago where if something goes to a patient in a hospital and it isn't used, it's returned to the pharmacy for possible use by another patient. So we have this "do not use" and an expiration date. So theoretically, it can still come back to the patient.
Well, do not use is generally shorter than the expiration. Like if I make something if I make an immediate use product, I've got an hour to administer it to the patient. I have to start the infusion. Well, the actual expiration or the stability of the drugs may be longer.
Right.
So it's typically shorter, do not start after, than the actual expiration.
So the question is, if the patient doesn't get it, can it return to the pharmacy for use by somebody else? Okay,
As long as it's been kept in appropriate storage conditions.
right.
Any public comment? Hi, Don.
Hi, Don Kaplan from Kaiser Permanente. Amy, I agree with you 100%. In my role, I oversee our 14 inpatient pharmacies at Kaiser in Southern California, and I have oversight over our pharmacists who do the programming in our electronic medical record for 38 hospitals. And I also work closely with nursing directors, nursing managers, and staff nurses in our hospitals on various hospital inspections. And everything you said is exactly true, Amy. When nurses see a label of an IV solution, and if it says do not use after, it immediately causes questions. Does it mean do not start the infusion after, or is it the expiration date? So do not start the infusion after is exactly what a nurse needs to be satisfied that that product is safe to start the infusion for as long as the infusion needs to run. Moreover, that was the intent of USP 797 when that language was originally written, so it's perfectly consistent with it. So, good job.
Thanks, Don. And this would be, Laura, guidance then from the board in terms of to licensees. But if we put it in the script as guidance.
Yeah, they can use it for a while, and then if we decide we need a reg instead of just guidance, we can go ahead. We're going to turn the FDA here.
Steve Gray from Kaiser Permanente. I agree completely with everything that Don just spoke of. I think that's exactly right, but realizing that that's for a hospital environment and the way things are there. Outside of the hospital environment, they're not going to have a label that usually says do not start after. Imagine that for maintenance medication, doesn't work.
What about home infusion?
Yeah, and home infusion, that might work out there. So I think your article needs to talk about expiration dates and explain various examples of words of similar meaning in different environments. Outside the hospital, you often see do not use after, you see discard after. Expiration date, or EXP in a date, is not understood very well by laypersons or the public. When you say, this is what we want you to do, discard after, or destroy after, we used to say before there was a take-back issue.
I'm going to have to disagree with you a little bit, Steve.
I think you need to explain the variations depending upon the type of product and the setting.
I mean, you know, when you have young kids and they're very focused on, is this good to eat, Dad? I mean, they are so focused on the expiration date on a bottle of milk or a can of soup. And so I would say that the public has become very aware of expiration dates. It's on everything, and it's called the expiration date.
Actually, Board Member Weiser, on a milk carton, you don't have an expiration date. You have a do not sell after.
Okay, do not sell after.
And so that's exactly my point, is that different phraseology is used different by different industries and with different
I'll have to
things.
look again at my milk carton.
In part,
See if my picture's on there, would you?
Because what I've noticed, no, I don't, excuse me for veering off the point here, but it won't be the first or the last time. But I've always marveled at the fact that what I perceive to be the expiration date on the milk carton is the day it goes bad. So I'm not sure. I'll look at it again, and you're very right. Well, I'll give him a maybe. I'll give him a maybe. Are there any farmers, milk farmers or any cattle?
The other reason I say this is because when pharmacists come from out of state, or pharmacy technicians, other states have expiration dates as to the period in which the prescription is still valid. So it can't be refilled after 1 year. That's an expiration date on the authority of the prescription. And that gets often confused when you use that language with the expiration date on the product itself. So the more that we can give education to clarify these scenarios, I think it's really better.
Thank you, Steve. And I think part of the way to look at it, Stan, is that I could make a product with a specific expiration date in different circumstances, and the do not start after will be different. If I make it in a segregated compounding area, it'll be 12 hours. If I make it on the desk, because it's immediate, and it's a crash cart, it's an hour. So there's different things that will, and part of it is that if it includes the sterility conditions the drug was made at. That's why that do not start after becomes really important in a hospital or in any infusion setting. Okay, moving on. Compounding matters, part 2. A, discussion and consideration of statistics for board-issued citations and fines for compounding violations. Board member Schad reviewed the compounding citations and fines that were issued by the board for sterile compounding. So he actually took, almost a year?
I took 700 pages, all the...
You noticed that he actually reviewed every one of those.
I did, every one of them. I'm going to read them to you today. Yeah. And so what I did was I looked at the number of citations, the number of institutions, and the variations among the citations. One of the things at the meeting that I found out that I was shocked at, and I'm still not particularly clear on it, is that of the 600 citations or so, it only that was only 75 institutions. They are all compounding citations that I looked at. And the compounding citations were the 735 for just regular compounding, and the 1751 for the sterile compounding. And a lot of those sites that had sterile compounding, as a matter of fact, 33 of those sites were also cited in the
So it was like it was 38 out of 1,100.
Right.
So that comes to a 3.5%
No.
citation rate.
No, it's lower than that. If you could, because there's over 1,000.
Yeah, out of 1,100, right?
Right.
So it'd be 38 over 1,100.
Yeah, that's
So
isn't that
a little over
0.3?
3%.
No, that'd be 30. It's 0.3.
Oh, really? 0.3. Wow.
Yeah, so that's an extraordinarily low,
Very low
citation rate, and that's why I was so surprised. And so, and then there were a variety of other things that caught my eye. One of is it 3%? Are you sure? Let's figure this out.
I'm going to check the math.
Well, 1,100, 10% would be 100, 38 would be 3%.
Oh, God damn it. Oh, excuse me. Wait a minute, is that right? Okay, don't argue with an accountant. No, I've had that problem before.
3.5%. 3.45%.
Oh, okay, everybody's right, except me.
Just did the math.
Okay. Okay, that makes it a little bit better. Okay, multiple cases of basic preparedness were not completed. And essentially, as we'll see a little bit later, that a lot of policies and procedures weren't done, basic policies. And I was shocked that this wasn't done, and so I'm wondering if we're communicating well enough. I can't believe that many facilities would have been so unprepared when we came in to look at them. So I'm concerned about, Jenny said that we want to educate, and we make every effort to, and we don't cite immediately, but I want to make sure that all the pharmacies are communicated with, because I'm shocked that there are so many that the inspectors found no or inappropriate policies and procedures. Something else that was a little surprising was sometimes the satellite locations in the same facility would be cited, resulting in multiple citations. That didn't seem to gel quite right. And also there are cases of training required for each hood location with no difference in hood type. I thought that was certainly overkill. And there appeared at times a degree of variability of the intensity of the inspections by an inspector. Some sites were looked at with a fine-tooth comb. Other sites were not looked at with a fine-tooth comb. There's a variety of comments on that. The fines for the same offenses seem to vary widely. And the overall nature of the citations seemed to change over the year. I don't know if that was because word got out, certain things were being looked at, or the inspectors were looking at different things. It was kind of hard to see, but they did change over the year. And, you know, it's hard to get an actual statistical analysis of what has been cited, because both the LSC, the PIC, and the facility are cited. So there's sometimes it's the PIC is cited for one thing, and the facility is cited for a couple things, and the LSC is also. So there's also a couple cases that I thought were interesting where the PICs were cited and fine, where the current PIC was cited, and the former PIC was also cited, and I wondered if there was sometimes I think that the current PIC might come in and be held responsible for things that the previous PIC has been responsible for. And then I could not easily determine the length of time from the inspection to the citation issuance. I thought there was great variability there. And then also something that on the 735s, the requirements for labeling magic mouthwash were there were lots of them, and this kind of brought up an issue where you've got a mixture of 3 to 5 different active ingredients, a variety of different formulas, and all these are labeled as magic mouthwash. And so, and there was and so consequently, the active ingredient wasn't included on the label, and there were citations for that. That's something that's going to have to be kind of clarified, I think. Also, something that kind of surprised me was that if you give a prescription to a wrong person, it becomes a HIPAA violation. I hadn't looked at it as that. I'd looked at it as a simple error. And a special irritation of mine is that there were 2 cases of compounding pharmacies that were cited for compounding commercially available products. And while this is indeed the law, it still irritates me. One of these is compounding of hydroprogesterone in oil. Essentially, it's a $10 drug that now costs $1,500 because it's made by, I can't remember the name of the company, but essentially it now costs $1,440 per injection, or $30,000 per pregnancy. And Time Magazine had an article on this in 2014. And then also I found an enalapril suspension, which is usually given to cardiac patients who are children or infants. Now there's a $300 commercial product that was sold for $15. And now this is my personal comment on this. I think this is just a great injustice to the patients out there. And so anyway, that's kind of a general review of what I found there.
Any board member comments or questions? Public comment. Oh, go ahead, Albert.
I have some feedback that on those non-steroidal compound is so strict that a lot of people stop doing the compounding for the pediatric suspension stuff. So I don't know, are we overkill on this regulation?
Well, part of that is because of the FDA. I don't think it's really the board, but the FDA's actually put out lists of the fact that there's a commercially available product, you can't compound it.
No, I'm not talking about that. I'm talking about the regular normal compounding that you have to require do so many testing and all this is cost so much. It prohibits them from making those compounding. So you're going to be denied a lot of service for those pediatric patients that are available before. And nobody will be doing compounding anymore.
Do we have the ability to do enforcement discretion on oral compound? I mean, I'm not talking about sterile, but non-sterile.
Yeah, the non-sterile compound I'm talking about.
Suspension that Alan was making. I mean, that's a simple suspension that most pharmacists.
I don't know what the circumstances are, what would lead to a cite and fine in one case and not to another. It's important to note that what the citations that Mr. Shad was seeing between January and December of 2016 would have been based on existing regs that have been in place for years. So those aren't new violations because the new regs didn't take effect until January, so they would not have been in that set. So what you were looking at is what we believe were like regulations, some going back, prior to even, 2003, when we promulgated the first real set of regs for sterile compounding after we had the California situation.
But I don't think he's referring to
No,
sterile.
no.
I think he's saying for like, if I'm
No,
taking
no,
a
it's a
tablet and I'm crushing it, and I'm putting it in simple syrup, and I'm giving it to a patient, sometimes, I think we heard the same thing at a previous board meeting from a hospital in Orange County, a pediatric hospital. But sometimes the costs for this are so high that the patients can't afford to pay for it.
Yeah.
Then to be
that's my point.
compliant with the FDA requirements, there needs to be a note from the prescriber stating that the patient would benefit from this drug because of this reason. And it's got to be patient-specific. Otherwise, you're compounding a commercially available product. We don't cite for it very often, so my guess is that there was some other circumstance going on in that case, because a single time, we wouldn't cite for it usually. So
No.
that there might have been something else going on that I don't know.
I'm not talking
I'd have
about.
to look at the citation. That response is back to Mr. Shad, though, not to you, Albert.
I'm not talking about the commercial available product. I'm talking about in general, those are pediatric compound that they've been doing in the past, very commonly done. And now, because the strict regulation, they have to do so much testing, it costs them so much that no longer anybody will be able to afford to compound it anymore. So I don't know, are we overkill on some of the regulation on those non-sterile compounds?
Well, the regulations that you'd be talking about, Dr. Wong, are really ones that have been in place since 2003. There is a testing, there is a quantitative analysis requirement that they're supposed to do some sort of testing based on the pharmacist or the PIC's professional discretion. Not every product has to be tested, not everything you do needs to be tested, but there has to be a plan there. And so that's one of the things the inspectors for years have been looking for, and that goes back more than, I don't know, as long as I've been EO, and even longer than that, back to 2003. So, I don't know.
Ellen, maybe we should bring up some of the examples that on the citations for these non-sterile compounding infractions. Maybe we could put an article on the script or something to clarify that is for public education, so all the pharmacists will know what is allowed, what is not allowed.
Yeah, that's kind of interesting. Now, are you saying we should say what people are getting in trouble for?
Yes.
Yeah. Okay. Yeah. Interestingly enough, there's something similar that's done in the state of Oregon. They review every year. They have a kind of a public meeting where they go over some of the hot topics that the public needs education from. Essentially, they get them from the PIC reports that are filled out by the pharmacists, and they're collated, and there's kind of a general statewide discussion.
Like the self-assessment forms?
I beg your pardon?
The self-assessment?
The self-assessment forms. And,
So it's more than just compounding, it's just any kind
well,
of...
now that's true, but in this case...
No, I actually think that sounds actually like a good idea, that maybe we should, think about it. And kind of goes back to what Stan was saying earlier, that, sometimes the board isn't viewed as, being fair and even, that maybe a meeting like that would be...
Yeah, I'll be happy to have all the data available for the public ed committee to review it and see how we could do a better job of educating the pharmacists.
That sounds good.
Yeah, Victor, we should have part of our agenda to look at maybe what Oregon does as far as that annual meeting.
Bring it to the communication and public ed.
Yeah.
Sure.
But one thing we typically do every year is we do list the top 10 violations of, assessed to pharmacies, assessed to PICs, and assessed to the dispensing pharmacists, so that people can see those.
Well, this was,
Is it in the script?
No, this is a little different.
Is it in the script you do that?
No, we provide it to the board in the board meeting. We've run them in the past in the newsletter, but it's been a while since we've run one in a newsletter.
I think what, and Alan actually shared the email with me about Oregon, and I think they actually do a webinar where people can ask questions, and it's an educational service to the public, to the licensees, about what they're finding.
Right.
So it actually, I think I agree, it sounds like a good idea.
But you don't
Art, Art Whitney, and earlier I was with Pacific West Pharmacy, but I also have a compounding pharmacy only. It's called Advantage. And I'd like to echo Dr. Wong's, the colleagues of ours in the state of California, many of them are getting out of compounding at the risk of a lot of patients not getting what they really need or want. And I'm not, I'm not sure what the answer to that is. Anecdotal, though, I can tell you that last year, our compounding pharmacy had a survey, or an inspection. It took 8 hours. No findings. This year, the inspector was there 30 minutes. No findings. So you can see where we come from. It's like, is there any standardization here? Am I teaching someone how to inspect a pharmacy by having him there? And yet the other guy, and the guy that there was an hour was bound to determine that he was going to find something. And when I pushed back on it, he retyped his report as we sat there in my office. So I think that's the problem we have. We have no problem in addressing whatever rules or regulations you want. Define them precisely so we can follow them. That's very, very important. Like right now, I just put in a $150,000 negative pressure room to do topical hormone compounds. And yet at the last board meeting, I heard rumors that, well, maybe hormones aren't hazardous. So how do we address that?
I think the regulations right now state that it is up to you as a PIC, if it's a table 2 or 3 NIOSH drug, for you to determine whether it's hazardous or not.
6 months ago, did it say that, when they said everything had to change January 1?
It's been in the draft regulations for a while.
I understand that. But if we're running a business and we want to comply, and in 6 months ago you said, this is what's going to happen, what are we going to do? We're going to respond. And we did respond. And now that's changed at a cost of $150,000.
Any other public comments? Okay. Moving on. Item B, update and discussion of the compounding construction waivers for new requirements in Title 16 California Code of Regulations, Sections 1735 and 1751. At the committee meeting, Supervising Inspector Christina Costa provided an update on compounding construction waivers that have been received. There's been a group of us that have been reviewing these compounding waivers, and I have to say, I think Supervising Inspector Costa has been doing an amazing job reviewing all these, the volume that we're getting. She does a first review, then we have a committee per what we decided at the last board meeting of Executive Officer Harold, and Julie Ansel, Alan and I, with Christina Costa, going over those that don't meet the general guidelines of a waiver. And the guidelines that we're taking is that if they show good faith effort in terms of trying to meet compliance, that we are granting a year waiver until the end of 2017. And we're basically, because construction timelines are so in flux, it's really hard for pharmacies to predict when that waiver is needed up until what time. So we figured after doing a year, they can reapply at the end of 2017 for 2018, and then we'll review them. Currently, as of January 2nd, 2017, the board has received 493 waiver requests and processed about 43% of them. So there is a backlog if the board hasn't responded yet. There are a lot that are still pending. There are still being received. In fact, I think on December 29th, the board received 70 just on one day, right at the very end of the year period, right before January 1st. The waivers, some of the issues we're having is some of the waiver requests do not reference the specific section in the law that is being asked to be waived that is construction related. The board does not have ability to approve waivers for non-construction related items. So if there is a waiver request for not allowing a specific definition or a policy, those the board cannot grant a waiver. It is only for actual construction. And the applicant needs to include that in the application. Some of what we're finding on the waiver requests, and Christine's spending a lot of time, I mean, I think one time she told me she spent several hours on the phone with one of the pharmacies just to do some education. We're receiving them from not only hospitals, but retail pharmacies, and working through that and having her educate them and revise the waivers and then resubmit them. There's certain entities that have submitted waivers that did not need to submit waivers. So those were actually pulled because there was no need for the waiver to be submitted. And if there's any additional information, Dr. Acosta is contacting them and spending time asking for that. She's working with several large health systems. There's actually a couple of health systems that are actually almost done
Right, yeah.
with the waivers. I mean, very proactively. I don't know, can we say that who they are?
I think they do.
I think they deserve,
to
I mean, I think
Yeah, they
Dignity
deserve-
Health has done an amazing job.
Dignity.
They've actually, I think almost all theirs are done.
They had a number
Yeah.
of facilities, I think like 20, 40, something.
Yeah.
Well documented, too.
And very
Yeah.
thoughtful waivers. They were very carefully submitted, and we were able to get a lot of, approve most of them, I think, already. So they're in good shape. We do ask that the pharmacies that have submitted waivers keep a copy of the waiver request in the pharmacy in case of an inspection to instruct the board, to let the inspector know that you've submitted a waiver. And that if you haven't heard back from the board, well, it may not have been approved yet, but at least
Well, right now for those inspections,
Yeah.
we're doing that, yeah.
to have it on there. There's actually, I know, an issue also with some of the equipment that we're finding that doesn't meet some of the standards, and we were going to send out a subscriber alert on that as well.
I don't think we finished doing the list yet, but
Yeah.
there's some concern about.
Some of the
types
MIC, the
yeah,
MIC contain, yeah, basically, and we're just alerting to be really careful and look at your equipment to see whether it is, if it's compliant with the regulations.
So Amy, can I just clarify this? So there's basically 214 requests that are being processed. 50 of them did not, they're not sterile.
So it was
70
basically non-sterile.
Regular
So it's like the
compound.
hormones that we just heard about.
Right. 70 were approved and 2 were denied. So that's like 100, that's like half of the 214. Is the other half still in process and you just can't put them in one of the categories?
Well, some of them.
What does that mean? I guess my question really is, what does it mean that they're in process?
Most of them, the reason they're in process is they haven't provided enough clarifying information.
Okay.
So they're still out, there's back and forth communication with Christine. She'll ask questions, she'll wait for the responses. So it's that back and forth that we're waiting on for some of these. And I think our goal from, our recommendation, at least from the committee, is that we really are here for public protection. So we need to allow the time for the pharmacies to do what they need to do, especially at the hospital setting, because there is no other options for these patients. So as
then
long
the-
as they're making a good faith effort,
And so
we
then
work with them.
the difference between the 493 and 214 is that number, 200, whatever it is. We haven't even started looking.
Right, but remember, that was January 2nd, so we're now the 23rd.
I'm not
Yeah.
trying to be, I'm just trying to understand.
Yes.
I'm not trying to be critical.
They're doing as much, I think she's doing as much as possible. I think we should probably see if we can get her some help with another supervising inspector.
I think the consistency is real important right now, and we're wading through it.
Yeah,
And-
I would
and
agree.
if we shift in midstream, we could end up with two standards inadvertently. I think it's better if we're just consistent. But we're all in this together. If we give you a waiver, we're exempting you from requirements that if you make a mistake, we're all in this together, and we're going to have the same problem that NECC's got right now with its regulators and the mess that they're in, where they weren't held to their regulatory standards either.
One of the
So
things
it's a problem for all of us.
And one of the things we're finding, although the new regulations were focused on USP 800 type with hazardous, there's still, Christine's still finding issues with 797 compliance, even sterile compounding compliance on some of the waivers that are requested. So those, I mean, that just tells us how big this issue is, and the fact that we are making good headway with the regulations in terms of improving safety for sterile compounds in the state.
It's a huge task, and everybody's got a piece of it that's involved in compounding.
We also are working directly with OSHPD, so they are part of our committee. I forgot to mention them.
So it's public health now.
And public health is also involved, so there's an alignment from all of the different, in fact, when someone provides an OSHPD number, Glenn just looks it up right away, and he goes, yeah, that's a valid OSHPD number.
Or that's not a valid number, which we're also hearing.
So one of the things that happened, for example, is that when the hospitals submitted a request for a waiver, they requested an OSHPD number, but if they don't follow up with the information quickly, that becomes an invalid OSHPD number, because they have to submit the applications in a certain amount of time. So we're finding that the OSHPD number, although it's listed on there, is not always mean that it is a real OSHPD number. So I think the alignment of all the different organizations working together is just going to lead to better public safety. Anything else you want to add, Alan or Jenny?
No, I said enough.
Okay. So more to come. C, discussion and consideration of the U.S. government account, I'm sorry, public comment, I should open it up, sorry.
Hi, Christine with Dynalabs. Is there, on the website, is there an example of a good waiver or a, you know, so that, because I know there's customers that ask me about what's going on with the waiver process and all that.
We've been asked to put online a copy of the waiver that was approved so that people would know how to submit one. No, because what's right for your pharmacy may not be right for your pharmacy or right for his
But
pharmacy.
the application's online.
The application is online. I thought you asked for a
No, I did
completed
ask
one that had been
I
approved.
did ask if there was an example. I did ask that.
No,
And you're
we've been
saying-
asked a couple times by consultants, and we've had one that's flat out said, we just want to know what'll get through. That is the wrong answer
course.
to
Yeah.
tell a regulator.
Okay, thank you.
And I think if you look in our past minutes, there's been some examples that were presented by Supervising Inspector Acosta at a previous board meeting. Okay. Yes, yes. All right, any other public comments? Okay, moving on to item C, discussion and consideration of the United States government GAO report to congressional committees on FDA has taken steps to implement compounding law, but some states and stakeholders reported challenges. And I think that Ginny kind of alluded to this earlier, but the regulation of compounding by states has, the boards of pharmacy are looking at other sterile compounding areas. At the ASHP meeting I was at, some of the other states are actually stating that they are looking at compounding that's being conducted in physician offices, not just pharmacies. Because, and I think we heard a mention of public comment earlier today, that as we start putting pressure at the pharmacy level to increase requirements, if we let the physician's offices also do those requirements and not do the requirements and just compound in any way, that there's going to be a safety gap for California patients. And other states are actually issuing licenses now to physician offices for sterile compounding. And they're bringing them just like they were a pharmacy. And if you think about it, it kind of makes sense, because when we have a physician dispense drugs out of their, or dispense a prescription out of their clinic, they have to follow the same regulations that a pharmacy does, including all the labeling requirements. So it kind of makes sense.
It does. That's just an analogous situation. And as a matter of fact, since those drugs have such a narrow therapeutic range, you know, we should be looking at those rather than with greater scrutiny. And so, and usually when they are dispensing them out of their office, it's not casual use. It's pretty intense use.
Especially if they're doing oncology preps
Right.
and to immunocompromised patients.
Yeah.
So their attachment 8 does contain a copy of the FDA GAO report. Any board member comment? Public comment? Moving on, item D, review of discussion of California law governing compounding and conflicts with USP Section 800. We actually asked staff to review USP 800 versus the California state regs to see if there's any areas where we may not be in alignment, and we discussed those at the committee. And we had Christine Acosta actually provide us with some recommendations on regulation changes that we may want to consider at the board. So there is a copy in your packet under attachment 9. The first one is in section 1735.1. In terms of the definition of compounding, the recommendation was to remove the word sterile from the definition of a biological safety cabinet, because they are used in locations, they're used for compounding drugs that may not be sterile. The other recommendation in that same language, and it isn't in your packet, so I am actually calling this out, is in the last line where it says this external venting should be dedicated to 1BSC or CAI, to remove the word venting and put exhausted, because that is a clearer term rather than the venting is just to use the word exhausted. So that was the
As in
recommendation. Pardon me?
Exhausted as in tired.
Not that kind of exhaust.
An air exhaust. The other changes on 1735.6.
Being a little boring.
Under compounding facilities and equipment, under item E, hazardous drug compounding shall be completed in an externally, and again, it's just through a word, change the word vented and put exhausted. So it'll be externally exhausted, physical separate room with the following requirements. Under item 3 of that same regulation, instead of each PEC, it'll change each BSC. In the room shall also be externally vented. And then additional language to be added is except that a BSC used only for non-sterile compounding may also use a redundant HEPA filter in series. And I know this is an issue that was talked about at a previous board meeting where some manufacturer or some pharmacies that do non-sterile compounding all would like to be able to use a redundant HEPA filter. USP 800 does allow that. So we are recommending, and I think it was Board Member Weiser's recommendation, that we move and be consistent with USP 800 and allow for a redundant HEPA filter instead of the, or in addition for an external venting. Now, is this another one in terms of externally vented? Is this one where we need to put externally exhausted, or do we keep the word vented there? I know we had talked just 2 instances, so we keep vented here. Okay.
We'll check. We'll check. Yeah.
Okay.
confirm with it.
And then the third recommendation, the last recommendation was to proposal to repeal Business and Profession Code 4127.7 so that we are consistent. I think this is just a inconsistent regulation, is that right,
With the
Ann?
building standards.
With the building standards. So we're just asking to repeal 4127.7. So that was the recommendation from the Enforcement and Compounding Committee. Any board member comments or questions? Public comment.
So, I just have a question. Since we didn't have the changes in the materials.
The only change that you don't have in the materials is
the
the
venting.
word vented is now exhausted. That's it. It is in all 3. Okay. So wherever you see vented, it's
So
clear
it's
to be
in
exhausted.
E?
It's in 1735.1C. It's in 1735.
I'm trying to find it in C.
Right there.
Oh, so not vented, this is venting, okay. So venting.
Exhaustion should be dedicated to one
and
BSC
then-
or CACI.
And then E where it says vented,
Vented will be exhausted. And then under 3,
where it says externally vented.
externally exhausted. So that's the only change you don't have, and I think that was one that came from Supervising Inspector Acosta, to make it clear since we're changing these regulations.
Well, we've had these discussions at various meetings over the last couple of months, so.
Oh, about the vented exhausted?
Yeah.
I'm not, that even I knew that was something that needed to be done, so.
I mean, the clearer we can make these, the better, I
Yeah.
think, for the licensees. I think the comment we heard before. Any public comment? Okay, if not, all in favor of moving, and we're initiating, is it initiating, oh, sorry, are we initiating rulemaking on this then?
Rulemaking and statutory modification.
Okay.
Hi, Paige Talley, CCAP. I have something informational and then something that is, I need clarification. Exhausting versus venting. Can you explain what the difference is?
Do we want to, I think this came from Christine, right?
I think that the term that's used in the industry perhaps is exhaust versus vent, so we found that out, so we decided to.
She's been spending a lot of time reviewing. I mean, Don, can you kind of, can you explain it for us?
Hi, John Kaplan, Kaiser Permanente.
Hi.
The difference is that exhausting is an active, forceful process where you have ducting and you have fan that forcibly removes the air from the plenum of the vertical airflow hood and forcibly exhausts it, ejects it out the building. Venting is passive. Venting means you could have ducting that just has an opening out of the roof of the building, but there's no way to assure that aerosols would be, toxic aerosols would be actually removed from the workspace and exhausted out into the atmosphere. So active versus passive.
So when they talk about venting the hood to the outside,
Well, venting is probably not an adequate term to describe what's actually done in air handling systems, where they have fans on the roof of the building that forcibly remove the air. They suck the air out of the rooms and out of, in this case, plenums of the vertical airflow hoods.
So do you agree, Don, that exhaust is a better term?
Yes, absolutely. And as we're designing our sterile compounding pharmacies and working with mechanical engineers, it's all about exhausting and proper capacity, and very important.
Thank you.
Thank you. Yeah, and I just have one other comment. I wasn't going to bring it up until Art did. And then you mentioned something, Dr. Gutierrez, about NIOSH table 2 and 3. And I know it was brought up last time that it was USP 800 allowed the risk assessment. And so I was concerned. So I looked, on page 84 of the final guidelines, it actually...
Which guidelines, 800 or...
USP 800.
Okay.
Yeah. It says that any HD API is considered hazardous. I mean, has to be treated completely with containment requirements. So then I sent a letter to USP and said, you know, I need some clarification, and got a letter back. Of course, they said it wasn't official because they do that, but it was from one of the compounding people, Jeannie Sun, who said, yes, that HD APIs and powder hormones are considered HD APIs, have to be treated completely within the rules of the chapter for containment.
This is one case where USP 800 may have higher level of requirement than the Board of Pharmacy does. So if we were to consistently do that, it would, I mean, you're citing USP 800 regulations. We don't, the Board of Pharmacy looked at those, but it's not necessarily
Oh, I
consistent.
understand. I understand that, but it was just that it was brought up at the last enforcement meeting that you can do that, even for USP 800, and you really, I don't think you can, and I just wanted to make
You're
that.
saying that what was brought up at the last enforcement meeting was the use of the redundant HEPA filters. That's what I mentioned.
Not only that, but also USP 800 stated that one could look at table 2 and 3 on the NIOSH list for HDs and do a risk assessment rather than compounding with them. But I know your rules are different, but it created, I mean, there were people, I was getting emails from people I didn't even know that said, oh, now we don't have to reconstruct our rooms or our building or anything. You know, we can just move on and do a risk assessment on the HDs.
Not for 800.
So, for 800, but not. So if they do that, then if they call them HDs, then they have to abide by your law.
Well, the State Board of Pharmacy, their current regs, as I understand them, is that it is all the cytotoxic agents or the oncology agents, and then it is up to the PIC to determine what additional agents are considered hazardous. So that's different from 800.
No, I recognize that. I was just trying to make clear that USP 800 isn't really saying to those people who thought they could just do a risk assessment on table 2 and 3 that they can't, even for USP 800.
I'll defer to 800 to interpret their own regulations.
Yeah, well, they did.
Thank you.
Okay, thanks.
Any other public comment? Okay, so do we have, and the motion from the committee is to move forward with rulemaking and statutory changes?
As discussed.
As discussed. So do we need a new motion to do that since we're adding this? Or, because the committee just discussed this, but you added some additional things on there.
Second motion, vote on the first one and just do a second motion. It's the easiest and speedy.
Okay.
I think to keep it clean, I would recommend just a fresh motion that includes everything that you want incorporated.
Okay. You want me to make the motion, Stan? Okay. That will incorporate just what Ann said, incorporate all these changes and delegate to the executive officer.
Second to refresh motion.
Second.
Second to refresh motion.
Right. And
Any other, I'm sorry.
Oh, I was just going to clarify, because I know this piece has a statutory component too, and then this is the pre-notice that we have to be done about the regulation piece, so it'll get pre-noticed, and then what you're delegating to the executive officer in this instance is the ability to make changes consistent with the policies that you're setting here today. So if we missed ventilated to an exhausted, we'll be able to make that change.
Thank you. All right, any public comment on the motion? All in favor? Okay, moving on to item E.
So you have another committee recommendation about repealing 4127.7?
We just did.
Oh,
It was part of the.
That was a statutory.
That's on the attachment of attachment 9.
Okay, it's just two different motions on the board paperwork. Sorry.
Okay, moving on to item E, presentation on requirements for sterile compounding master formulas. Because of the fact that one of the things we've noted is that when Dr. Acosta's done presentations on enforcement findings, one of the big issues is what exactly is a master compounding formula. So we had her do a presentation on what are the requirements of a master formula. A copy of the presentation is attached in attachment 10 to the meeting minutes. And we also asked her to provide examples of sample compounding formulas or compounding master formulas that she has found acceptable. And I think those are now on the website, Jenny?
Yes, I'm pretty sure they are. I saw the draft copy of them before they got up there, so I believe they're up there.
Okay.
Oh, okay.
So we'll have those up just to provide some guidance so that we have more education and not the I gotcha on the findings. We want to do as much education as possible. So this will actually provide some good guidance to pharmacies on what to be expecting on a master formula. Any board member comments? Any public comment?
So
Okay.
I'm sorry, what's in here in attachment 10 is okay?
Yeah.
Yeah, but you can't read some of them. They're really small, and it's very difficult to read. And I think she wanted to redact some of the information. So, I mean, I couldn't read that on the screen. So we asked her to provide some larger copies and and we're going to post them on the website. Okay, item F, discussion and consideration of the FDA rule, proposed FDA rule, list of bulk drug substances can be used to compound drug products in accordance with Section 503A of the Federal Food and Drug and Cosmetic Act. On December 16th, the FDA proposed a rule of list of bulk drug substances that can be used to compound drug products, and it addressed 6 bulk drug substances the agency had evaluated and is proposing for inclusion that can be used in compounding under Section 503A. There's also 4 other bulk drug substances that the FDA evaluated and stated cannot not be included on the 503A bulk list. If the proposed rule is finalized, these will be the first ones included on this list. So Dr. Acosta and I agreed that we need to just further discuss it at the committee meeting because at times we may not be fully aligned with what the FDA wants to do, so we need to provide some input. So I think that's an item for future discussion. I don't know, any other comments regarding that? Any board member comments? Public comments? All right, Part 3, General Committee Matters, the enforcement statistics. A copy of those is found under Attachment 11. And their future committee dates for 2017 for the Enforcement Committee are listed: April 18th, July 12th, and October 17th. Location to be determined, correct?
Probably Sacramento, but yes.
Okay, any board member comments? That concludes the enforcement and compounding. Any public comment? All right, moving on to Org Development Committee. Item 11.
Madam
Yes.
President, can I ask a quick question?
Yes.
Do
you want to do closed session? Do you want to just go into closed session? I don't think this is going to be long. Okay. It looks like it's just 4 pages. Okay. Is the Organizational Development Committee report. Budget update report, fund condition report. Attachment 1 includes the fund condition reports prepared by the department. Yes.
Can we save the organization committee report until tomorrow and go into closed session? Because we may not have enough time. There's some people may not be here tomorrow.
Laura and I just discussed it. We think we can
Oh.
get through this pretty quickly. It doesn't look like it's very long.
Okay.
Yeah, and then we're going to go into, we have to go into closed session. But there's not much here. I mean, there's just like 3 pages. A lot of this is personnel updates, which I'm sure Jamie can quickly.
We don't need to, you can read those for yourself.
So attachment 1 includes the fund condition reports prepared by the department, and you'll see that the months in reserve for 2017-18, 5.2 will go up to 6.1 in 2018-19. Budget for fiscal year 2016-17, oh, I should say, any board member comments on fund condition report? Public comment. Item 2, budget for fiscal year 2016-17. On June 27th of last year, the governor signed the budget for 16-17, which began on July 1st. The board spending authorization was actually adjusted down, right?
Yeah, but that's for a record-keeping reason.
And the reduction reflects a change in how statewide pro rata payment is billed. The statewide pro rata of $1,165,000 will no longer be reflected as an expenditure line item on the budget and will now be a direct withdrawal from the board's reserve fund. That's what you were talking about.
We're still paying it, it just won't show up in our budget.
So, are you talking about the reduction from our reserve fund?
No, well, effectively, that's where it's coming from, but our annual budget, we pay a portion of our budget directly to the state for the provision of services it provides to us as a state agency. Our share of that is the, what is it, 1.6 million?
2.5 in pro rata, right?
2.5 million pro rata as well, 1.9. No, it's a 1.16 million, yeah, 6 million. This is for the state, yeah, that's separate. So what they're doing is they're taking the money out directly from our budget and not showing it any longer as a line item deduction in our line item budget.
So,
We're still paying it, it just isn't there.
Right.
It's removed. It's sucked out as a vacuum cleaner gets in there.
Good.
Probably how many of our licenses.
so anyway, so the original budget was $20,600,000, and however, that's been adjusted to $19,400,000.
Right.
Which is a difference of about $1,200,000,
Which is the
$1,187,000.
1.16, yeah.
1.187. So we are getting 1.2 million less in funding or for our budgetary needs. Is that correct?
No. We are paying the same amount as we were before, but that 1.16 million is being taken off in a different manner than it has in the past. Before.
Okay, so it's
in
not
our
a,
budget,
okay,
it's not discretionary. We have no
no,
control.
it's not a double hit.
No, it's not a double hit. It's just the manner in.
Okay.
It's an
Okay.
accounting, maybe Greg needs to provide this.
What you're doing is you're reducing the expense and reducing the revenue?
No, you're reducing the expense in the budget, but it's coming out of the general board fund as a direct removal, and it's not showing in the budget. It's the way the governor's choosing to do the budget differently than in the past. We will continue to track this because this is part of our expenses of government.
Yep.
This is part of what we have to pay, and we have no ability to say we're not going to pay this.
No, that's, but
No,
to
no,
me,
no.
it feels like a double hit. I mean, we're getting less,
I think he's saying it's a reduction in expense and a reduction in revenue, but it's equal.
but they're taking the money out. But anyway, Greg, if you're okay with it, I'm okay with
We'll
it.
talk about this in a couple minutes.
Okay. I may need some liquid refreshment to help.
If we have to do it that way, then so be it.
We got some water right here. Is that-
Water's good. That's usually what I drink.
The budget information for the
It's
current.
what they call creative accounting.
This meeting is going on too long. Keep going.
Budget information for the current fiscal year is available through November 30. During the first 5 months, the board received approximately $9.7 million in revenue. About 88% of it was through licensing, 8% in citation fines, 4% in cost recovery, and a little bit under 1% in interest. The board has expended about almost $8 million, or about 41% of its authorized budget during the first 5 months of the fiscal year. The largest expenditure, personnel, was 67%. What was interesting to me is that the enforcement and the pro rata are about the same. So 13%. We're actually spending as much in pro rata as we are in enforcement. in terms of the dollars.
That's DCA pro rata.
Yeah.
That's DCA pro rata too, yes.
And that's what we need to really, that's one of the questions I asked earlier when we had DCA council is, where is that money going to? So that we actually get a more, because that's a lot of money.
It is a lot of money.
Yeah.
Attachment 2 includes a detailed budget charts for board revenue and expenditures. Board member comments? Public comments? Item 3, DCA distributed cost allocations, including breeze costs. The board monitors its budget and receives quarterly budget reports. The board pays about $2.7 million in pro rata to the state, a portion going to DCA. During the October 2016 board meeting, members requested that information regarding the board share of the breeze system be provided in the future. Based on the information provided by the DCA Budget Office, the board contributed over $1.2 million in breeze costs through June 30, 2016. Is that part of the pro rata or in addition to that? So we've given $1 million in pro rata and another 1.2 in breeze.
Yes.
Yes, the 1.2 in breeze was not a single year, it was allocated over a couple of years.
And the board can contribute another 1.2 between 16 and 2019. Now, this is a system we don't use.
Correct.
So why are we paying it?
We've asked that question.
When that meeting is scheduled with the DCA Budget Office, that might be a good opportunity to ask.
That'd be a good idea, yeah, just to see.
I just want to clarify something to Stan. I just reread this, and what they're doing is, instead of taking it as a P&L item, they're pulling it out of the balance sheet. So they've got a reserve on the balance sheet, right? And then you've got your income and expense. So now they're not taking it as an expense, they're pulling it out of the net reserve fund that's accumulated on the balance sheet. So it's kind of like going against capital instead of going against income.
I like the word I used to describe it, but whatever.
Attachment 2 includes the DCA breeze costs and funding that details the board's portion. And these are all out-year numbers that are current estimates and not official until approved in the governor's budget. Board member comments, public comment.
Where are you now?
On the breeze. Page 2, DCA distributed cost and breeze costs. Item B, board member reimbursement information. Attachment 4 summarizes all the board members that have sought reimbursement for expenses and per diem payments. Not every board member board members may opt not to receive hours for reimbursement, and it's not uncommon for that to happen, and the details are in attachment 4. Board member comments, public comment. Personnel update, Ginny, do you want to give us highlights? They're all listed.
You can see the changes in staff with about 120 staff. Someone's always coming and someone's always going. Our inspector positions are all filled with the exception of one position, I believe. We're hoping to add 3 positions with the governor's budget that starts July 2017 to staff the outsourcing program. The outsourcing, we would get a new supervising inspector and 2 inspectors specifically to handle the outsourcing duties. And the outsourcing supervising inspector would also pick up a portion of the compounding duties that are currently being performed by Christina Costa. So having 2 equal teams there to cover the very sensitive compounding that's performed.
Thanks, Jenny. Attached on item D is future board meeting dates that are listed, May 3rd to 4th, July 25th to 26th, and November 7th to 8th. We also have the February 17th Automated Drug Delivery Device Demonstration Summit that we described earlier.
Do we need to point out the 7th to 8th, I think, are slightly, oh no, we were going to change it to the 8th.
It was the 8th and 9th. We changed, it didn't get changed there, but it is on our website now.
So, right, you have
7 to 8.
It should be 8 to 9.
Yeah.
It's 8 to 9?
Yeah, we fixed it on our website, I believe.
Okay.
To avoid
November,
election day.
it's 8 to 9 because the 7th is election day.
It better be changed to 11.
That concludes the org development report. Now we're going to go into closed session, and I'd like to announce that we are going to be discussing the following litigation during closed session. 1, Sacramento Superior Court case number 34-2016-80002456. And in addition, we will also be discussing Santa Clara County Superior Court case number 16CB300271. That will go into closed session now.